This is the case number 2000133MM. Benjamin Royal, in his official capacity as executive board member of the Detroit Federation of Teachers, et al. There's a whole series of persons, will not name them all, versus Governor Gretchen Whitmer, Director Robert Gordon, Superintendent Michael F. Rice, Mayor Michael E. Duggan, and the Detroit Public School Community District. If this is a hearing set for today on a motion by the multiple plaintiffs seeking injunctive relief, we would ask that all of those parties who are participating in oral argument present themselves and be allowed to be admitted into the Zoom conference. This will take a few minutes. As this occurs, I'm going to indicate what papers the court has in its possession regarding this particular matter. The court is in receipt of the complaint filed. It says a verified class action complaint seeking injunctive relief and a request for an ex parte temporary restraining order filed on July 14th, 2020, and received by the court officially on the 15th. The court is in receipt of an answer filed on behalf of the multiple state defendants. That was filed on the 17th. Well, it was received on the 17th. It may have been filed before that. The court is also in receipt of both a motion for summary disposition and brief in support of that, filed on behalf of the Detroit Public School Community District, as well as an answer received today in opposition to the request for injunctive relief. The parties have given the court multiple exhibits. The plaintiff has given the court a copy of a briefing report from the Community Interventions and Critical Populations Task Force of the CDC's COVID-19 emergency response as Exhibit A. It has given us as Exhibit B the Detroit Public School Community District's reopening plan. Exhibit C, additional documents from the Center for Disease Control. Exhibit D, an affidavit from Mr. Seifert, and an affidavit and a declaration from Ms. Carr, whom I believe is Mr. Seifert's daughter. And I may have that confused. And Exhibit E, a declaration from Mr. Peck. Exhibit F, a document which, amongst other things, includes a copy of a 7/9/2020 email by Dr. Vitti. And Exhibit G, a statement from Mr. Edmond, and pardon me, that's where the declaration of the 6-year-old Ms. Carr is found. Please excuse me. Exhibit H, a communication from a DPSD email with the last name of Wright, sent to a party whose email name appears to be and address appears to be LILMIKA 70 regarding placement of a certain student. And Exhibit I, a statement from Jackson and a statement regarding a Jenkins minor. Exhibit, that's I. J, the Michigan Safe School Start Plan from the governor of the state of Michigan. The state defendants have given the court, to the best of my knowledge, one exhibit, that being the governor's executive order regarding the opening of schools. It is listed as their Exhibit A, I believe. I do not have any exhibits from from the DPSD. I have no response, nor do I see a proof of service on Mayor Duggan. If the parties could please unmute yourselves and uncloak yourself, I guess that's what we'll call it, so that the court may see you as well as hear you. Okay, at this point, I do not see the plaintiff. I see Ms. Roberts, who has the task of trying to record everything. I see Ms. Husa Briggs, Ms. Shaw Hicks, Ms. Mitchell Ford, Mr. Theophilus Clemens. I still do not see or hear Ms. Driver. She is disconnected and we're waiting for her to reconnect. Technology works until it doesn't. Ms. Driver, if you could unmute yourself, and if you are on a computer, please reveal yourself. Could you state your appearance for the record, please, on behalf of the plaintiff?
I'm sorry, hold on. Let me just call Ms. Driver. I'm her clerk. Hold on, sorry.
Pardon me?
I can try, but I don't think they're going to hear me.
I can hear you.
Oh, you can? Thank you. Okay.
So, Ms. Driver, why are you not visible? What's going on?
Honestly, I don't know why. The link isn't working on my iPad or on my phone, so I am on somebody else's laptop, and I don't see myself on that either.
No, you're not. Did they have a Zoom application on their iPad already? Or whatever device you're on? Had they downloaded the Zoom program?
Yes.
And then you followed the link.
Now I just saw myself saying that I'm talking, but I still don't see myself.
Okay, now I see Mr. Garcia, who is a surprise. All right, Ms. Driver, could you state your appearance for the record?
Yes, I can, Judge. Shanta Driver on behalf of Benjamin Royal and the other plaintiffs in this case.
On behalf of the state defendants, could you state your appearance?
Good afternoon, Your Honor. Assistant Attorney General Elizabeth Husa Briggs on behalf of the state defendants.
On behalf of the Detroit Public School Community District.
Good afternoon, Your Honor. May it please the court, Janice Mitchell Ford, General Counsel on behalf of Detroit Public Schools Community District and Superintendent Dr. Nikolai P. Beatty.
And you are joined by two of your colleagues who
Yes,
can state their appearances.
Good afternoon, Your Honor. Rebecca Hicks on behalf of the DPSCD defendants.
Please the court. Good afternoon, Your Honor. Theophilus Clemens on behalf of the DPSCD defendants.
Mr. Clemens, if you're going to be speaking, you're going to have to project because we could barely hear you. I understand that Ms. Mitchell Ford is handling the argument, so it's less important, but just in case you do have to say something, use, as I tell my grandchildren, your outside voice, okay? Okay. Mr. Garcia, I see you here. I think I know why you're here, but I don't have a formal appearance or an answer filed by the entity that I know that you represent, but could you indicate what's going on?
Thank you, Your Honor. May it please the court, Lawrence Garcia, Corporation Counsel for the City of Detroit. I just received word of the existence of this suit and the paperwork attendant to today's hearing yesterday. It's been a very busy last 24 hours. I apologize. I have not had an opportunity to file an appearance. I have a great deal of respect for Your Honor and for the court, and I wanted to attend this hearing in the hope of helping resolve matters.
Okay. Has your client been served?
No, Your Honor.
Ms. Driver, I know I don't have a proof of service on behalf of the mayor. Did you serve the mayor?
Yeah, I'm sorry. My understanding was that we could serve Mr. Garcia in person and that he would accept service for the mayor. And he was emailed yesterday, and then he received direct service this morning from one of the assistants in my firm.
Your Honor, I have received paper copies of the complaint as well as an electronic copy yesterday, but I have not consented to accept service on behalf of the mayor yet. That's a conversation I was hoping to have with Ms. Driver.
Okay. Well, I went through the list of everything that I have received. I have no idea if you heard it, Ms. Driver. Did you?
I'm sorry, I did not, Judge. I was so frazzled trying to get this to work.
From yourself, I received exhibits A through J. I assume you know what they are?
I do.
Okay. And from the defendant, the state defendants, I received a copy of the governor's executive order. I have not received any other exhibits. We're here today for a hearing on a request for injunctive relief. I am not, nor has anyone asked me to, be prepared to receive witnesses at this time. To that end, I am going to presume that the plaintiff would make an offer of proof that the individuals from whom she has a verified complaint, who have made affirmative statements, those persons including Mr. Royal, Mr. Peck, Affiant Seibert, Declarant Edmund and Carr, would, had they been called today, have testified consistent with their declarations, affidavits, or statements. Is that a fair characterization, Ms. Driver?
Yes, it is, Judge. Thank you.
The defendants who have been and who have acknowledged service and for whom proofs of service have been filed have raised defenses in part to whether or not there is irreparable harm. But the principal nature of their defenses, if I could characterize them, would be, as relates to the Detroit Public School Community District, that this court does not have jurisdiction over it. And as relates to the state defendants, that no allegations have been made against them for which wrongdoing could be found. Have I fairly characterized the defenses on behalf of DPSCD?
Yes, ma'am.
And on behalf of the state?
Yes, Your Honor. I also want to add, Your Honor, that we don't believe that the injunctive relief requested as to the state defendants is available under the law. So that was also included in the response.
So the way in which I would like to proceed is that both for the sake of listeners who have nothing to do with this case as parties, and for them, to the extent that they're representatives of the Fifth Estate and they want to understand what the heck we're doing in here, that the plaintiff will state her case as relates to each class of defendant or each category of defendant. And then each defendant would state their case as relates to the relief requested. The plaintiff would be afforded the opportunity for brief rebuttal, not repetition, but rebuttal. As relates to the defendant for whom no service has been, proof of service has been filed and no acquiescence to service has been given, the court would first inquire, given the nature of the complaint, whether oral argument would earnestly be sought.
No, Your Honor, I'm just trying to figure out what's going on. So I'm happy to just listen, but I don't really understand this suit.
No, here's what I'm trying to figure out. I can, at some point, your client's going to be served in my lifetime, at which point you'll file an answer. We either have oral argument as relates to that singular defendant or we don't. I'm not asking you to waive response. I'm asking you, do you really want oral argument? If you
No.
do, we'll schedule another one.
No,
Ms.
thank you, Judge.
Driver, as relates to the mayor of the city of Detroit, are you earnestly seeking oral argument, or would you be satisfied with the papers that you have written and whatever paper you write in response to their answer to your complaint?
Yes, I am. I don't think we need oral argument. Thank you.
Okay. We all agree on how we're going to proceed?
Yes, Your Honor.
Now, you are at a disadvantage, Ms. Driver. Can you see us even though we can't see you?
I can. Thank you.
Okay. So as you know, we have Ms. Roberts, who is our court reporter. At any point in time where either there's a technical issue and she cannot hear us, or we talk in a way that she didn't understand what we were saying, or we all talk at the same time, she may raise her hand, send me a note, do something to let us know that we need to stop so that she can get a clear record. If she does that and I'm aware of it, I will make you aware of it. If any of you notice her raising her hand and I don't, I ask you please to interrupt so that we can get a fair record, okay? All right, Ms. Driver, you may proceed.
Thank you. Thank you, Your Honor. I would like to start with the Detroit Public Schools and specifically Superintendent Beatty. Our claim is the following, Judge, that that the school district Superintendent Beatty did not follow the guidance of the governor that was provided in her last executive order 2020-142, as determines what can happen with school opening. And that instead of following what the order asked for, which was up to develop a plan, to submit that plan to the superintendent of education and to the body that the governor had created to oversee the reopening of schools, DPS decided unilaterally that it was going to open. And as a result of that, there have been children who have been sent to the Detroit Public Schools, 26 of which are open for in-class teaching right now. And they have entered those schools without any kind of preparation in terms of COVID-19. The bus drivers who we could definitely produce if if this hearing goes into a hearing that is going to require testimony. Will say that they were never told that they were to wear masks, to use hand sanitizers, to carry out a protocol, to separate the children so that they would be at a safe distance from each other. They also were never told that it was going to be their responsibility to provide students who were on the buses with hand sanitizer, with masks, and with social distancing. So when they went out to pick up the students, they learned that, in fact, once they returned, the students, once they came back to the bus yard, that the students should have had masks, should have been given hand sanitizers, and they should have had the same PPE equipment so as to prevent spreading COVID-19 amongst the children. None of the bus drivers, to the best of our knowledge, and we have talked to quite a number of them, were also told that they should be pre-tested to make sure that they were negative for COVID-19 prior to being assigned a school route.
Ms. Driver,
Including
Ms. Driver,
yes.
are the bus drivers at issue employees of the district or employees of vendors?
They're employees, they're both. Okay, there's some bus drivers that are subcontracted, and there's some bus drivers that are hired, that exist and work for the district themselves. But whether they're subcontracted or whether they're employees of the district, they had to be, Judge, in our opinion, appraised of what the dangers are to the children and what the dangers are to them of being able.
Ms. Driver, you don't distinguish between the duty of an employer to its employees and the duty of an employer to its subcontractors. In other words, if it's First Student Bus, isn't First Student the employer of the bus drivers for First Student? And isn't,
I think
pardon me?
I'm sorry, Judge. I think under these conditions where absolutely everything has to be done right, minimally, even if the bus drivers were hired by a bus company, the bus company itself should have provided those instructions to the driver.
I don't disagree with you, but I'm just suggesting to you that there is, I don't know how you find a duty from DPSD running to employees of somebody else.
They're the organization that subcontracted these employees, and I know that they did it as a contract so as to free themselves from any responsibility for the action.
Why they did it, Ms. Driver, doesn't change the law of the state of Michigan. At best, you can make a claim on behalf, and your claims are constitutional too, which are interesting. So you're making a claim on behalf, you have a basis to make a claim on behalf of those persons with whom DPSD is in an employer-employee relationship. But as relates to those persons who are employees of other entities or corporations, I do not know of any legal theory under which you're going to find a duty owed to inform them. And if you know of such a legal theory, please share it.
I don't, Judge, but I do think that the district has a duty to the students who are picked up on those and placed on those buses to provide them with safe transportation and to provide them with a way to get to school that took into consideration what needed to be done to satisfy the protocols for safe reopening that exist under both.
Okay, Ms. Driver, I think we all have a clear understanding of the nature of the harm that you believe and what you're opposed to. I would be interested in understanding why, as relates to DPSCD, this court has jurisdiction, please.
I think it has jurisdiction because I think that from the standpoint of judicial economy and from the standpoint of what is the different defendants that are in this case, you have exclusive jurisdiction over some of these defendants, both in terms of asking for injunctive relief, but also if we are given the right to amend our complaint and include mandamus in it, the right to use your powers as the judge that is given responsibility, exclusive responsibility and jurisdiction for claims against the governor and the superintendent of public education and of the Michigan Department of Health and Human Services.
Okay, so you would acknowledge that I don't have original jurisdiction as relates to DPSCD, wouldn't you?
I would agree with that, Judge. And if that was the only defendant in this case, that would
But that's the only person, that's the only entity we're talking about right now. If I don't have jurisdiction over DPSCD, even if I agree with everything you've said, I have no power to do anything.
I think that you do. I think that from looking at the Flint Water Board case, I think that there are exceptions that can be made, both because it would make no sense.
Tell me what about I'm sure you mean the Flint Water case, you don't mean the Water Board, but could you tell me what from the multiple cases against the state actors and those operating as emergency managers under state authority in the Flint case would give you rise to a belief that I have jurisdiction over DPSCD?
Judge, I don't think that, I will concede that under normal circumstances, I don't think that you do. But I think in terms of this case, the idea of carrying out two separate trials, two separate proceedings, if it comes to that, one of which would be in circuit court and one of which would be before you, all of which would contain the same evidence, the same testimony, at least on the part of who the plaintiffs provide, that it only makes sense for DPS to remain in these proceedings if they—
Counsel, you have to give me a basis for me to exercise original jurisdiction under DPSCD. Whether or not the parties might choose, once a case is filed in the correct court, to stipulate that they just as soon all be together than to spend twice as much money and twice as much time, is something else. But at this point, regardless of how I may feel about or intellectually analyze your complaint, I do not have a legal basis as a court of limited jurisdiction, as opposed to the circuit court, which is a court of broad jurisdiction, to do anything. So unless you've got a case or a statute, the fact that something may not appeal to your sense of common sense or to anyone's sense of judicial economy does not deprive the legislature of its authority to decide what jurisdiction I have.
I understand, Judge, and it may be that we'll certainly seek, and it may be that we'll be able to ascertain a stipulation from the Detroit Public Schools and Superintendent Beatty to agree to proceed under your jurisdiction in a single trial. We will, obviously, we're going to file in circuit court or in federal court if we cannot get that kind of stipulated agreement from the district and Superintendent Beatty.
Well, as at this point, you don't have it. You know that clearly from their papers.
I I do not have it. That is correct, Judge.
So do you want to, at this point, stipulate to a voluntary dismissal without prejudice against DPSCD?
Yes, Judge, because I really feel like these proceedings should continue and can continue. I think the other parties in this, you have jurisdiction over. And
Well, okay, let me just real quickly ask you, how do I have jurisdiction over the mayor? So we can like save some dancing time?
I would say possibly with the exception of the mayor, which is fine. Judge, just to cut to the chase, at the end of the day, you do have the power over Governor Whitmer. There is no question about that. There's been a ton of litigation. And
Okay, I'm not there. We're just trying to get, you're going to voluntarily dismiss DPSCD without prejudice. You will file in Wayne County Circuit Court, and the substance of your issues will begin to be joined there. Do you agree, even though you haven't really served him yet, that you will do the same as relates to the mayor of the city of Detroit?
yes, Judge, we will do the same as relates to him if you grant a motion to dismiss him without prejudice.
Well, I don't have to dismiss him because he's not joined yet. He's named, but he's not served. So that would be you agreeing to dismiss without prejudice.
We'll do that, Judge. Thank you.
Okay. So while there are many issues that are very thorny and you gave me a lot of information, could you address your claims against the state defendants, please?
Sure. I think that the Governor Whitmer, who is the governor of the state, has an obligation to protect every citizen of Michigan against bodily harm. And I think that's an affirmative duty that she has. And I think she has not carried out that duty in regards to the students, teachers, school staff of Detroit. And not only is that relegation of her duty to provide for bodily integrity, I think it is also an action which gives rise to due process claim, federal due process claim, but also an equal protection claim. Because for Detroit to be singled out as the one school district that is allowed to ignore the governor's executive order and reopen schools under what are tremendously dangerous conditions, and to have no action by the governor taken either affirmatively in the form of another executive order requiring DPS to close, or enforcement of the order that she already issued around school openings. I think that just smacks of discrimination. It just continues what has been the long process, historic process of Lansing choosing to single out Detroit for discrimination that will harm the city, and in particular, the young people of Detroit in this case, and then all of the school takeover stuff that preceded this. It's just discrimination. We think it's based on racism, and we think because of that, the governor is also should also take action.
Okay, so your claim against the governor is that she isn't enforcing her orders.
That's correct.
Okay, and the failure to enforce her own orders is a denial of substantive due process?
It is in the sense that the children of Detroit have a right to undergo the same treatment under the law and to be afforded the same protections as any other child in the state. And I think that there is a showing, or that deliberate indifference is being, that is what the governor is doing. The governor had a press conference talking about how she was concerned about reopening other school districts even in September, full well knowing that the Detroit School District is operating now, offering in-school classes without any kind of protection for the students. And I think that students have the right to expect equal protection under the law and the right to ask.
Has the governor, so the governor issued a guidance, is that correct?
She did, but the guidance are binding, as I understand them. They're not just a guidance.
You believe that the guidance is such that any district which violates the guidance has violated state law?
Yes, I do.
Okay.
Especially where the
help me understand how a guidance becomes law. I know how an executive order becomes law. Gosh knows I know a lot about that. But what is there about a guidance that in this circumstance would allow me to say that it is the law of the state of Michigan, and that violation of that law of the state of Michigan should have some sort of consequence?
I think in the case of the order around education, it's...
What order? Are we talking about 142?
Yeah, we're talking about 142.
Okay, what have you pled in your complaint that alleges the governor did anything about 142? Or that anything was a result of Executive Order 142? Because I may not have been reading it carefully enough.
Okay, if that wasn't clear, then we apologize, Judge, but it certainly is the defense of the governor that 142 is what absolves her from responsibility for carrying out that order. So it's definitely before the court, and this order...
Okay, I wish I understood that a little better. I don't. I think I heard you say that the governor says that 142 is her defense against 142, or do you mean against the guidance?
Against our complaint. That's what
your complaint is, that she is not enforcing the guidance.
Correct. And
if she says 142 is her defense against the guidance.
Against her character.
Against her enforcement of the guidance, right?
Right.
Okay.
But the guidance has specific mandates. It's not just we recommend this or that, which is something that's prominent in a lot of the other executive orders that have been issued. She says in this particular executive order,
it's not please, let's be careful about when you're referring to the EO and when you're referring to the guidance. So if you're going to quote from the EO, say EO 142. If you're quoting from the guidance, please do that, because I want to make sure I'm looking at the right piece of paper when I listen to you.
Okay, thank you, Judge. I'm looking at the executive order.
142.
142. If you look, for example, at page 3 of it, where it says preparedness plan acting under the Michigan Constitution of 1963 in Michigan law, I order the following. And under that order is under number 2A, one, a requirement of closure of school building to anyone except, and then it goes through categories of people except district employees or contractors, food service workers who are preparing food for families to pick up and take home, licensed child care providers, and in point number 2, suspend athletics, after school activities, school activities, e.g. debate, competitions, and busing. And busing is definitely being undertaken by the Superintendent Vitti in the district right now. And that seems to be a pretty clear directive and mandate in the executive order that the governor is saying relies on the Michigan Constitution and is not being followed. If you go to the next page, to page 4, it says that each school district will describe the policies and procedures that district will follow when the region in which the district is located is in phase 4 of the Michigan Safe Start Plan. These policies and procedures must, again, there's no wiggle room here, at a minimum require wearing face masks, wearing of face coverings except during meals and unless face coverings cannot be medically tolerated, for all staff and all students in grades pre-kindergarten and up when on a school bus. And that particular mandate is also being violated by the district, and the governor is casting a blind eye to that. And then B, all staff and all students in grades pre-kindergarten and up when in indoor hallways and common areas are also supposed to be wearing protective gear. And it goes on from that. It just skipping ahead to something that we haven't talked about already. It says in point number 3 on page 4 that it is that the return to school roadmap issued by the governor requires protocols in place for hygiene, cleaning, athletics, screening, testing protocols, and busing and school transportation. And again, that is not being followed. There are
who is it that is responsible for enforcing the executive orders?
I think the school districts are in this case, and
Well, that's not going to help you because they're not parties. How does this? I said enforcing. I'm going to assume that for our purposes, there's a violation of this executive order. Who enforces that?
The governor. The governor has
The governor doesn't enforce her own orders. Isn't there another state officer that does that?
Either the governor could do it in this case, I think, or
How does the governor enforce her order?
the attorney general could enforce her order.
I just want to be real clear. If it's a violation of an order which has a criminal penalty, how is that enforced?
That would be enforced by the police or some.
No, the police would do a citation. Okay, and then, and the case would be brought on behalf of whom? Would be brought by a prosecutorial authority, right?
Correct.
What is the penalty for violation of Executive Order 142?
I think that the court struck down the right of the governor to be able to set up new criminal standards for violation of her orders in one of the last cases, but it did allow for $500 penalty to be appraised if the orders were being violated, which is the standard amount for a civil violation. I think in this case that.
Okay, so you're saying you want to look to another source to determine what is the violation process for 142?
Yeah, and we think that ultimately that source is you, and it's going to come to you one way or another.
No, okay, if we have an order that's violated, it's either violated when a court order is violated, it's either a civil violation or a criminal violation. Are you asserting that violation of Executive Order 2020-142 is civil?
I am.
What right does the individual citizen have in the state of Michigan to enforce this order? And how does she or he acquire that right?
I think that an individual citizen has a right to enforce this order through the proceedings that we're going through now, because an individual that.
Then what is the role? What is the role of the Attorney General?
I think the Attorney General should act and could act to enforce this order, but in the absence of that, then I think the citizens of this state have a right to go to the appropriate court and ask that this order be implemented, because they are the people who are going to be affected, directly affected.
And that appeals to me intellectually, but legally, when we look at who has the right to enforce, in most instances, there is no private cause of action. So I'm trying to understand how there is a private cause of action in this case. And what's the source of it?
I think there's a private cause of action in this case because of the circumstances under which these orders have been developed, because they exist as a unique body right now of law in the state of Michigan. And
Ms. Driver, if I go into a store and I see an individual without a face mask, do I have the right to enforce the face mask rule?
I think if you go into a store and there's a sign in the store that says face masks are not required here, then yes, I think you have.
Well, there can't be one. There's an executive order that says face mask in all indoor spaces. So when I go in to Kmart, if I could find a Kmart, there aren't any, that's why I picked that one. If I go into Kmart and people don't have face masks on, do I have the right to sue Kmart or the individuals?
I think you have the right to first. Yes, I think you have the right to demand that the people wear face masks. I think you have the right to call the police to take action.
Okay, see, there you go. I have the right to call the people who have the right to issue the citation and bring the case. I don't have a private right to either throw a face mask on them and get socked or sue them. I have the right and the ability to go to the law enforcement agencies and seek relief. And while this is certainly a dire, deadly disease, the potential harm, can't direct how I act as a court. I've got to follow the principles of where there is a cause of action pled, and I've got to follow the principles as to whether there is standing to even bring a cause of action. So if your complaint against the governor at this point is actually what you want me to do is not to enjoin, you want me to issue an order of mandamus.
We do. That's correct, Judge.
That's not what, this is a hearing on an injunction.
I understand that, Judge, and I know that we need to modify our complaint to include mandamus. But yes, that is what we are asking you to do, and we're asking you to do
And
it.
you know that you haven't pled mandamus, and therefore the AG is not prepared to respond to mandamus.
I know that, Judge. I would just ask that the judge accept, give us leave to amend the complaint right now to add mandamus. And I know that that may require a future hearing, but it's got to be fast, Judge, because somebody's got to stop this, and everybody.
Okay, counsel,
Somebody else is.
you know, I would just be gentle with that. Certainly, it'll be as quick as is in accordance with that due process of law thing that you pled. But you drafted the pleadings. I didn't. And I understand that it was done under the urgency of the circumstance. But if you're going to amend the pleading, you have to do it as quickly as you can in accordance with your duty to your clients and get service on the defendant remaining so that those defendants can have the opportunity to respond to it. On behalf of the Attorney General, I think that you heard that your colleague has said that indeed the relief she was seeking against you, the equitable relief, is probably a deck action and mandamus.
Yes,
Would
Judge.
you, at this point, when is it that you believe you would be filing your amended complaint?
I think we could file it today, Judge, and I think we could serve it today.
Would you be prepared on behalf of the Attorney General's office representing the state defendants to accept electronic service of an amended complaint?
Yes, Your Honor.
And I know that you're saying you'll do it today, Ms. Driver, and I know that that is your intent, but probably as a prudent lawyer, you should probably commit yourself to tomorrow, which means Monday, because, so let's assume you get the pleadings and papers amended and filed with a courtesy copy to counsel on Monday. If you get a copy on Monday, by when do you believe you would be prepared to respond on behalf of the state defendants?
Friday?
Okay.
Judge, I would, urge.
Okay, let me explain this. Actually, I actually do take a day off every now and again. And so I'm not going to be anywhere having a hearing about anything until from next Thursday morning until the following Monday. So if you believe it is urgent enough that it needs to be heard before then, I can certainly transmit that request to the Chief Judge of the Court of Claims, Judge Murray, and he can no doubt find someone else who can hear it. Otherwise, I'll hear it on that Monday. That's absolutely your choice, Ms. Driver.
I think if the Attorney General is not going to be able to respond until Friday, and that is accepted by the court, then Monday is the next time we would have a hearing in any case. So that would be fine.
The earliest that I would ask her to respond to this would be at least 2 days, which is Wednesday, and I'm not going to be here. So if you want a hearing, I'm sure that we could find some judge of the court who would hear it on Thursday or Friday, if that's what you would like.
Judge, I find it, generally speaking, best to continue with a judge that you have. And in particular, in this case, Friday, there wouldn't be school anyway. And so it would be Thursday versus Monday. And,
Okay. So we'll agree
you know,
that on Monday, gosh darn it, I don't have a calendar in front of me. Who has a calendar to tell me what a week from Monday is?
8? Let's see.
The 24th.
24th at 11 o'clock?
Oh, a week from Monday?
No, I'm sorry, Your Honor. Monday week would be the 27th.
Okay.
27th, okay. 27th at 11 o'clock?
that's fine for us, Judge.
Okay, so we'll get, I really do believe you can get your response by Thursday. I really do. And which will give everybody a chance to digest it, and I can, read it on my vacation, which will be exciting, my whole 2 days. And I will be able to enter the orders of voluntary dismissal on Monday, unless you can get them in today. If you get them in today, I'll issue them today, and that would give you a chance you'd have enough time to refile your papers in Wayne Circuit today, Ms. Driver.
Yeah, we will get those into you today. Thank you, Judge.
Could we ask the people who are being dismissed to draft the orders to leave? In other words, could DPSCD draft the order of voluntary dismissal and just get her acquiescence by phone? Mr. Garcia, even though you're not in, could you draft one that says you're dismissed voluntarily? And if you get those in, and if you send them to my legal assistant, Victoria Lockhart, whose email you will soon get, but not on this YouTube, then she'll get it to me before close of business today. It'll get signed so that therefore we can actually have them accept the paper without it being rejected at Wayne Circuit.
Yes, Your Honor.
And all of this, the easiest way to do this, Mr. Driver, is to file electronically. But if you really want to trudge down there, go right ahead. I wouldn't.
Thank you, Judge. As soon as those orders are provided to the court and the court's been able to sign them, then we will move forward in Wayne County Court.
And the way we're going to do this is I am taking your oral representation on the record as acquiescence to an order that is a voluntary dismissal. So I'm not going to ask them to send it, although they're going to send it to you, but to send it to you to get your signature and everybody comes back to me, that's just like too much trouble. And on behalf of the Attorney General, who has absolutely no horse in that particular game, I'm sure you'd agree as well. That was the silent Attorney General. Okay. All right. With that, we will be this matter will be adjourned to a hearing solely on a request for injunctive relief as relates to the state defendants pursuant to an amended complaint, which will be filed by Monday and to which a response will be filed by close of business on Thursday. I'm sorry, close business on Thursday. Thank you.
Thank you, Judge Stevens.
Thank you.
Thank you.
We are adjourned.